Yes, we're live.
Yeah.
Let me see once again. Yes, we are fully live. Yeah. So, should I go ahead?
एक बार उसको पूछ लो लाइव, क्योंकि यहाँ हो सकता है
Yes,
अलग
yes.
अलग
No, live. We have
सेम
gone
लिंक
live.
सेम
Yeah,
लिंक ना।
same link.
तो ट्राई करता हूँ फिर से। वो एंड स्ट्रीम करने से बार बार अभी आई कैन सी बट
Yeah, I can see there is another one. I think जो हम देख सकते हैं.
है ना, कुछ हो रहा है लेकिन वो लाइव नहीं हो रहा है अभी सुभाजीत।
Oh, I think.
It is live, but this is another. I'll send you Subhajit. Maybe you can pass it
Yes,
on.
there is another one.
अच्छा,
That
मेरे
has
को
been
भेज देना।
because that one, the old one, did not work. So yeah, I
यार,
think.
then we'll have to also just share it on social media, नहीं तो लोग फिर वो ये हो जाएगा।
Yeah, I'm just first sharing.
हाँ, तो मुझे शेयर कर दो, then I will just share it.
Yeah.
First share. Yeah, okay.
Yeah. I have. Is it visible now? No?
हाँ, I think ये better है।
I think it's now coming clear.
ठीक है, चलेगा। Okay, कर दो तुम।
Okay. Yeah. So I'll just take 1 minute to just reshare. Just 10 seconds. I'll put it on Twitter and.
Yeah. Okay, I don't think people will get this link because what we have shared is something else.
There was a small technical issue, so let's let know. Yeah, so I've done that. I have shared on Twitter. Yeah. Yes. But I will just mention. I have mentioned both of you in one tweet where I have reshared the whole thing.
Okay, I'll just.
Yeah, I think it's live, right?
Yeah, it is live. It is live now. Yeah, so I'm just then going to start. Okay, so a very good evening to the Indian audience and those are watching in other parts of the world. good afternoon and other things to them. I actually formally welcome all of you. The earlier link that we had shared on social media and other places had some technical issues. So there's a new link in the same YouTube profile, which is in my name. So you can still join with the new link. I have shared this on Twitter and so on. So before I start, I'm sure that this is an ongoing discussion which has basically culminated after the 1st August judgment of the Supreme Court, seven judges constitution bench. So I have been hosting, or probably I have decided to host a series of discussion to discuss and critically look at the entire judgment on the issue of subclassification of the scheduled caste and scheduled tribe reservation, or let's say SC and ST list. And in fact, the judgment has also come out with with an advice to put a creamy layer in the SC/ST reservation, if possible. So, but before I formally give sort of a small intro about the judgment, let me first thank our two very esteemed panelists. I can't thank them enough because it's been a very short notice. I have just got them live here with us. Professor Sumeet Mhaskar has been a very old dear brother for a long time. So Professor Sumit Mhaskar is a labor sociologist. He has been across the world in various parts of the world discussing labor and caste and so on. So he is right now with OP Jindal Global University, working there as a labor, teaching labor sociology. And he is basically a labor sociologist. With also, so I formally welcome Professor Mhaskar for joining. And also with us, Dr. Shailesh Kumar. He has been again, I can't thank him enough because he, on a, again, very short notice, he has agreed to be part of this panel. He has been, again, in global academia. He is right now with Department of Law and Criminology of Royal Holloway at the University of London, and has been writing on, and he has been also keeping a very close track on the issues of reservation and caste and so on. So I welcome Shailesh sir for being part of this panel discussion. So before I formally invite to deliver the lecture, I would again like to introduce this very idea of this panel discussion. With all of these three members of this panel, we probably on a very consensus basis decided that we would be decoding the political economy of substantive social justice. Therefore, to understand the SC/ST subclassification conundrum that has come before us. So, this is probably for the first time come in a big way, the very idea of substantive social justice. I was just checking in a very informal way in the 565 pages judgment that there were almost 35 times they have talked about or mentioned substantive equality. This very idea of substantive equality has been promoted, and Chief Justice of India, D.Y. Chandrachud, has written a specific chapter on this very idea of substantive equality. So it's very interesting that the way he probably, has been trying to analyze this whole idea of substantiveness in the SC/ST reservation. So he goes on to discuss Article 15, Clause 1, 6, 16, and so on. And this judgment is again, this while Justice Chandrachud is discussing substantive equality, is very interesting because what I felt is that I am sure that Sumit, Professor Sumit Mhaskar would be also shedding a broad light on this. But overall, this whole judgment, if you look at it, it has created a huge uproar even in the public sphere. That there have been a Bharat Bandh recently, and which has been a very, very democratically resisting the this judgment, and they said that it is an attack on the SC/ST reservation, which is constitutionally sanctioned and constitutionally mandated. The academicians have been writing. Professor Mhaskar himself has written an article. I have written an article where we have been trying to put across so many questions on this, and trying to say that this whole idea that has been manufactured, and the economic backwardness and economic forwardness, uplifted Dalits and non-uplifted Dalits and so on. So how it's again, some of us have sociologically, politically, even anthropologically, even archaeologically are finding it very, very difficult to create categories within category, and especially a category which is historically marginalized, where there has been a lot of struggle by none other than the Constitution framer, Dr. Ambedkar, the chairman of the Constituent Assembly, and the Law Minister of India, former Law Minister of India, Dr. Ambedkar has struggled for so many years to get a deal which would be safeguarding and protecting the historically oppressed, caste oppressed communities, like especially scheduled caste. So there are so many areas that can be discussed. Article 341, Article 342 came in a very big way in the judgment. So this judgment basically is a Davinder case, Davinder judgment, which has basically reversed the earlier E.V. Chinnaya judgment. Chinnaya judgment was again a very, very magnificent judgment. One of the specific judgments, separate judgment, has been written by the one and only tribal Supreme Court judge in the history of the Supreme Court, Justice Sema. And he said that once in the article, in his separate judgment, which is basically a concurrent judgment, he says that once the SC/STs are put in a presidential list and through parliament, it becomes a homogeneous category. So we can't leave it to the states to sort of get into it. And very interesting, if some of us have also heard in the few months back when there was a live proceedings on this case going on, senior advocate Mr. Sanjay Hegde made some very, very compelling arguments. He said that you cannot subclassify these two categories because you cannot measure the tent of untouchability, because these the scheduled caste category, as you know, that has been kind of created on the basis of 10 points, untouchability points. The 10 untouchability points are very, very important. So these are the communities those have actually faced through those tents, which is through the untouchability. And he made another point where he says that if we leave it to the states, it would be politically used, and there is a chance that the entire SC/ST list would be balkanized if it's classified and categorized and so on. So so many issues basically are before us as a panel, and of course they are to discuss. So I'm sure that we will try to cover all of that, and we could get no better persons than this panel. And so with these words, I wouldn't take much. We will have discussions at the end, but before that, I would hand over to Professor Sumit Mhaskar so that he delivers his lecture.
Thank you, Subhajit, for taking this initiative and also organizing this very important discussion. And I think as part of a democratic process, deliberation is necessary. So agreements and disagreements are part of democratic process. And just because some sections disagree on certain parts and other agree on certain part doesn't mean we should stop discussing. And in that spirit, what I would like to share certain context which are missing in the Supreme Court judgment. That suddenly we are talking about Supreme Court judgment. We are celebrating that it's a great step forward in what is called as substantive social justice. I will begin with some small basic information because there is always this confusion somehow that when we talk of reservation, people who are not aware of these kind of provisions, just because SC/ST and /OBC is written, everybody thinks that they are more or less interchangeable, and they are not. Scheduled castes are people who have historically faced untouchability, and only they are part of the scheduled caste list, and it's a separate scheduled caste quota for them. Scheduled tribes are all the tribal communities, Adivasi communities, who have been kept away, or for various reasons they have been away from the mainstream society. They are part of the scheduled tribes list, and because of which they have never managed to gain access to educational and occupational mobility. And the third group is other backward caste, who have been classified on the basis of social and educational backwardness. So these are three separate groups, and the current judgment only applies to the scheduled caste and scheduled tribe. So that is the first point of clarification I wanted to begin with. Now, the second point of clarification that I want to start with is that this judgment is applicable to scheduled caste and scheduled tribe. And what it tries to do now is tries to split the quota on the basis of people who have benefited slightly better and who have been left behind. So that is a simple logic. So if we have 16% of the quota for scheduled caste, depending on the region of population, then a part of that reservation of 16% would be kept for those scheduled castes who have been left behind, and there are scheduled castes who have benefited. Now, this is where the problem begins, that there is a section of population who have been demanding for the last, at least in some states in the last 20-25 years, in other states the history is a bit longer, that they want a separate assured quota within the scheduled caste quota, which means that they will have a guaranteed position in higher education and employment, public employment opportunities. Now, this is where we have tensions. One group suggests that no, this will dilute the provisions. And there are genuine concerns that they have raised in terms of how reservation has been implemented historically. And in most cases, all kinds of excuses have been used to not implement reservation. And therefore, those who are opposing the subclassification, their kind of opposition also comes from the long history of non-implementation of reservation in higher educational institutions as well as in public employment, that is government employment, whichever sector, educational or non-educational sector. So the fear that they have is a genuine fear that this might become another tool for not implementing reservation or to subvert the reservation policies. On the other hand, the groups who have been left behind, they obviously feel that this is the way out. Now, one thing we must have to acknowledge the fact that any group in a democracy, once they begin to feel that if this is the only way out, you cannot convince them otherwise. So, for example, the Jats, the Patels, the Patidars in Gujarat, and the Marathas in Maharashtra, they feel that reservation is the only way out of their current crisis. So there is no way around that you can convince them that no, your condition can be improved through other means, although I have argued that it is possible. So coming back to the SST subclassification, that as I said, that there are two groups, one who feel that they have been, or one we know that they have been left behind, and they argue that obviously they need a special protection. Now, where do we stand as far as this judgment is concerned? Now, as far as the judgment is concerned, of course, it has been celebrated that this is a remarkable judgment and it has taken substantive social justice ahead. Now, what do we mean by substantive social justice? That social justice does not remain merely on paper. That it is not just important that the constitution or the various government that advertises various positions either in higher education or in the jobs, it does not remain on paper that 16% is for scheduled caste and 7% is for the scheduled tribes. That it also means that substantive social justice has to happen. All these seats have to be filled by the various institutions. Now, has that happened so far? The answer is no. Of course, there have been great strides. We have actually made inroads into various institutions. The government has been implementing various policies, and there are various reasons. I'll come into that. But in terms of substantive social justice, we still are far ahead, behind in terms of that. And there are enough statistics to show that institutions such as the Indian Institute of Technology even today have absolutely negligible proportion of scheduled caste and scheduled tribes and other backward castes into their institutions. Also, the Indian Institute of Management. These are only two classic examples, but there are wide-ranging institutions where the representation is extremely low, despite the fact that there are eligible candidates who appear for interviews, but they're rejected on various flimsy grounds by saying not suitable candidates. So, to that extent, the judgment has rightly pointed out that yes, we need to do substantive social justice. Now, the fact that, at least as a scholar on the Indian society, I must admit that right now, the way we are looking at this particular kind of issue, so the judiciary has pretty much given a green signal for either the sub quota or sub classification within scheduled caste and scheduled tribes. And that is definitely going to be the way ahead as far as the judiciary is concerned. Political class has always interested in kind of making use of these different divisions within the scheduled castes, and I'm sure scheduled tribes as well, and therefore they are more than happy. So these are all non-scheduled caste parties, non-Dalit political parties, who are more than happy to have such kind of provision. So you have political parties, you have governments, and you have the judiciary. So in all likeliness, we are going to go ahead with subquota. That's the reality, and we have to face it. Haryana government has already started the process. Andhra, Telangana has started the process, and other states will soon start the process. So no matter whatever we do in terms of petition and review petition, not much is going to change. This is my view. Now, this is where I think the judgment has not been seen properly. That yes, the judgment is actually taking the question of social justice seriously. They have actually seen that okay, some groups have been left behind, and they are trying to include them into the beneficiary groups. However, what we are not talking about is the context within which this judgment is given. Right now, we are in 2024, and as far as the government jobs are concerned, of the total 100 jobs that exist in India, only 3.5 jobs are in the government sector where reservation will be applicable. And within the 3.5%, it's only 16 or and plus 7% where the jobs are there. The bulk of the jobs are in the class 3 and 4 group. And half of these jobs are already contractualized, which means they do not offer you a permanent job with social security benefits, healthcare benefits, or the right to negotiate with trade unions. None of these rights exist. So now we are really talking of 0.5 or less than 1% jobs. So when we talk of reservation, we have to remember that we are talking of a very tiny share of jobs where this reservation has been historically applicable, and even now that is the case. So before people celebrate the judgment, we have to also take into account the political economy of this judgment. So second part here, I'll come to the education sector as well. So jobs are absolutely negligible. So we are at a stage where all governments, all state governments and central government positions are extremely contractualized, and they are just increasing the contractualization. And in this regard, the Supreme Court has absolutely failed. That while doing a substantive social justice. It did not issue a directives to the state governments, to the municipal corporations, to the central government that they should stop contractualization of the jobs. That without having access to jobs, how can justice happen? And this is something the Supreme Court has deliberately remained silent. So, if the Supreme Court was really interested in substantive social justice, the first thing they should have done is to issue directive to all the governments to not hire people on contractual basis. And that is the way to go ahead. And that's why the context is important. The second part here is about higher educational opportunities. And the same remains the case. I have already produced statistics in the article I have written for the News Minute. And I have clearly shown that there is a massive move towards privatization of higher educational institutions. And even the governmental institutions have higher fees, which simply means that even though the government is now opening up a substantive social justice, not only those who have been left behind might not benefit, even those groups who have been benefiting so far might be excluded because of financial compulsions. That you need minimum amount of money to enter these institutions, whether it's public or private. Private, for sure, you need massive amount of financial capacity to enter those institutions. Here too, the Supreme Court has deliberately ignored the fact that the government should also issue scholarships to students from these groups so that substantive equality can be actually practiced. So this is the context. So before one actually takes the Supreme Court judgment into out of context, it's necessary that when this judgment is given. Now the second part where I personally think less scholarly attention has been paid while making subclassification. So subclassification, as I said, if one group feels like in Maharashtra we have the Matan community, you have the Arundhatiyars, you have the Madigas. So these are the Parsis in Uttar Pradesh and various groups in different parts of the state. If these groups feel that this is what is the way ahead, then one cannot necessarily stop that. But the rationale behind these exclusions are not necessarily taken into account in a very fundamental manner. The point here should have been that what has exactly stopped these other groups who have not benefited from obtaining the benefits. Now, the entire burden the Supreme Court has done is it has put on the beneficiary group. That somehow, and this is where the problem begins, that these groups have managed to take over, and in the popular discourse anyway, all these groups, whether it is the New Buddhists in Maharashtra or New Buddhist Mahars or the Chamars in UP, or you have the Parayas, all these groups have been targeted for accessing those benefits. Now, here one should really look at what exactly must have stopped the other groups from actually accessing benefits. Number one, we haven't really investigated the role of bureaucracy, that it is the bureaucracy's role to implement reservation. And we do not have any commissions properly instituted, and Supreme Court has absolutely put its hands away from these kind of discussion to look into investigations where particularly bureaucracy has played a role in subverting reservation policies. Number one, that would have actually taken care of all kinds of groups, and probably the subclassification issue would not have emerged if the reservation policies would have been implemented in the most effective manner. So bureaucracy needs to be targeted. Okay. Now bureaucracy on its own cannot necessarily behave the way they want. Of course, in some manner they can. It is here the role of ruling political parties is very important. That ruling political parties have not shown any genuine interest in implementing the reservation policies. You take the example of any government. You take the BJP government in various states. In the right now, they are ruling for the last 10 years. Their record is not necessarily impressive when it comes to implementation of reservation. The Congress government. You also take the various state governments ruled by, let's say, Communist Party in 34 years in West Bengal, and you have Communist Party in Kerala. there is absolutely no difference as far as the implementation of reservation is concerned. So in some sense, except for political parties which have the scheduled caste or Dalit mass base, or to certain extent, OBCs I'm not discussing right now because this is exclusively discussion about scheduled caste and scheduled tribes, that except for these political parties, the willingness of all other political parties have been extremely hostile in terms of implementing the reservation. So that's second group. The third group here are also all the opposition parties in the last 75 years. So none of the opposition parties have made these kind of uh, demands on the ruling establishments to actually implement the reservation. So what has actually stopped different kinds of scheduled caste groups from not accessing benefits is first bureaucracy and second is political parties, both those who are ruling and there's also those who are in the opposition. And as far as the political parties with scheduled caste or Dalit mass base, they have been not necessarily very strong, except for UP, and that also begins later in late 80s and 1990s. And of course, the last actor is the civil society. India is known for having a very vibrant civil society, but the civil society itself has never taken up this issue except the Dalit civil society, which has taken the issue. And therefore, this particular judgment needs to be taken or read in the context about the kind of jobs, number of jobs that are available to the scheduled caste and scheduled tribes, and the higher educational opportunities and the privatization of education. And third is to look away from the beneficiary groups and to look at the implementing authorities, the bureaucracy, the ruling political parties, the opposition political parties, and the civil society groups. And all of them have pretty much, I wouldn't say failed, because failed would mean they have made an attempt. There was never such an attempt. Now, when then we actually understand some of these groups benefiting? So you have to look at the context of political mobilization. But before that, just a last point here is about the Supreme Court has taken into account a discrimination within discrimination, which is to say that some untouchable groups, Dalit groups, untouchable groups, are facing discrimination within untouchable groups. And that is a very weak evidence the Supreme Court has used. I'll just give a very quick example and then I'll move to the next point. Historically speaking, Dalits were prohibited, they were actively prohibited from entering the schools where non-Dalit students are taking education. That the parents of non-Dalit children would object to Dalits entering the school. And that is a clear case of discrimination, caste-based discrimination. That they will not send their children if an untouchable boy or girl sits into that classroom. So if we take that example for the current context, we do not have any evidence which says that the beneficiary untouchable groups, that is the new Buddhist Mahars in Maharashtra or the Parayas or other groups, have actively prohibited the non-beneficiary groups or less beneficiary groups from entering the schools. That would have been a classic case of discrimination within discrimination. The second example here is that several of these untouchable groups are not in a position of power to make decisions who will get the job or not. And therefore, to put the blame on the beneficiary groups is nothing but criminalizing them. I have written in detail about how targeting the beneficiary groups is actually criminalizing them. First, we have to understand that whether a person has benefited slightly better or those who have slightly left behind, both are untouchables. So therefore, all the policies that were meant for scheduled caste were meant for all the untouchable groups. Now, why did some of these groups benefited more? There are historical explanations. There are explanations that these were the most conscious groups, these were the highly politicized groups, and they were the ones who pressurized various state governments, various local governments, and the central government to implement the reservation. They were successful to a large extent, and that is the reason you see a mobile group in terms of economy within those communities. And there has been a success story to a certain extent. So there is no disagreement on this particular aspect that a certain group has benefited. But they have benefited at the cost of political mobilization. And these are the groups who are also at the receiving end of the state machinery, that the government would use violent kind of methods and all kinds of humiliation these groups have experienced. That is to say that even though best beneficiary groups never had a red carpet treatment in either schools or higher educational institutions or government offices, even when they got the jobs, they were discriminated inside those workspaces. So even while entering, there is discrimination. Inside the office, there are discrimination. And there are all kinds of autobiographies that are written which document these kind of discriminations. So therefore, to target these groups for benefiting is nothing but criminalizing them and taking the discussion away from who is responsible for implementing the reservation, the bureaucracy, the political parties in power. And that is something that several social justice scholars are also trying to divert the attention, that they call these neo-Buddhists or the pariahs as leading castes, and they have pretty much created the leading caste as an abusive term, that somehow the beneficiaries have to feel a guilt of actually going and claiming their own right. Of course, there is a need to talk about people who have not been able to benefit more from these policies. That is different than targeting and abusing the beneficiaries who have actually access to these kind of provision through hard struggles, and they had to face violent consequences for actually accessing those benefits. And these kind of social justice kind of scholars, or maybe they are pretending to be social justice scholars, and these are the ones who are targeting these beneficiaries. What they have absolutely do not want to talk is that the Ambedkarite movement has actually been a success story. That yes, whatever communities may have benefited, but an Ambedkarite anti-caste movement has actually been successful in accessing those benefits. And this is something that they have to take into account. Because if we go by their logic, technically, none of the scheduled castes should have benefited. Only then we can say that yes, all scheduled castes are equal and all scheduled castes are homogeneous. And this particular kind of understanding continues to criminalize these. And that is something that needs to stop. Because a healthy dialogue is necessary between the scheduled castes. Those scheduled castes who have benefited and those scheduled castes who have been left behind. Non-scheduled caste commenting on the scheduled caste kind of in a very criminalizing manner is nothing but a form of newer form of caste discrimination, that you are being abused for actually benefiting from the schemes which are also meant for you. And this is something that needs to be noted, that within the scheduled caste communities there can be discussions about how other groups can also benefit, but to target those beneficiaries who already, despite their economic mobility, face different forms of untouchability in their workspaces and in their public life, to again target them that you are benefited, is nothing but criminalizing them and to put them in guilt for benefiting from the policies which they were also eligible for. In fact, these are the very groups who have been at the forefront for the OBC reservations as well. As a student of Jawaharlal Nehru University in 2006, we know that Arjun Singh implemented the OBC reservation for higher education. And it was these what is known as the beneficiary groups. They were at the forefront of leading the social justice. Despite the fact there is a long history that as far as the reservation for scheduled caste is concerned, there is absolutely no group that has stood with them as far as implementation of reservation is concerned. In fact, the scheduled caste has to bear the brunt of all the kind of anti-reservation sentiments throughout the last 75 years, and they continue to do so. And therefore, we need to look where exactly it matters. So, if substantive social justice is an important concern, then substantive social justice has to be implemented by the state government, by the bureaucracy, and the civil society, which also is more influential. They need to use their powers to implement that. Otherwise, even for those groups who feel that they will be empowered with the new subquota, uh, they might actually be disappointed. So, therefore, where to look for in terms of who will deliver justice, that needs to be taken care of. And that is something the Supreme Court has absolutely remained silent on. And that otherwise, if we don't take those things into account, we would actually fall into this particular trap that, again, yes, these are beneficiaries, they are the ones who are within quote stealing, cornering the benefits, and such words are absolutely problematic. They have a very much casteist undertone in terms of abusing those communities who have benefited. And it is precisely on this point, I'll add, that the judgment is unconstitutional on the part of creamy layer. So they could have discussed some of these things, but as far as historical literature, even the contemporary findings are concerned, it is very clearly established that just because there is economic mobility does not guarantee you a position of non-discrimination. That is, that you can still face discrimination. And there are ample of evidences of people who are economically mobile, but they face caste discrimination in the places of their work as well as their residence. And therefore, the Supreme Court, there was no need for the Supreme Court to even comment on creamy layer, because this is something called a settled debate. This is a settled debate that does not need to even be discussed. And yet there is a reason that you always continuously need to engage the Dalit population with some kind of the other struggle to even settle the what is to unsettle what is settled debate again and again. Now, as far as today's uh, uh, you know context is concerned, we need to understand that as far as social justice as a consensus, that there needs to be social justice and caste needs to be the parameter for social justice, there is absolutely no doubt that the Ambedkarite movement has played a very important role in creating that social justice discourse. And they have been far more open to having people from other marginalized groups on their platforms to talk about social justice. So if today you have a leftist, you have a liberal extending the support for social justice, we have to credit the beneficiary groups who have actually worked hard to create the discourse on social justice. But at the same time, we have to remember that all this consensus has come at a time when there is absolutely low proportion of opportunities in education and jobs. So all these various radical ideologies, even now they may say that they support social justice. But if you look at the kind of opportunities that are available, it's absolutely nothing. And therefore, the consensus also means nothing in that sense. That when they were in power, they could have done much better. And therefore, this kind of lip service now is of actually no practical use. To put it in the Supreme Court judgment word, it does not constitute substantive social justice. So yes, people will say that their political party now actually is in support of reservation, but it is meaningless to a certain extent. And that needs to be taken into account. So I'll come to the last part, which is what is the way ahead now? So this has been the situation. We need to talk about this. So what is the way ahead? And this is something I stated at the beginning, that as far as historically, if you look at the judiciary, it has been against the reservation policies. The Supreme Court or any judges have never been in favor of reservation. They have always found some of the other ways to not rule in favor of reservation policies. Same thing with political parties. They have been more or less against reservation policies, absolutely militantly against reservation policies. And so is the bureaucracy. Now, if we keep this facts in mind, then the way ahead is absolutely challenging. And it is challenging because, as I said, the political economy has changed, and therefore it is even more acute that those who are now going to benefit from the subcode or subclassification needs to intensify the struggle. Of course, some people have said that those who have benefited should lead the struggle for everyone. That, I think, needs to be the case as well. But to put entire burden, I would use the word, on the beneficiary group that only they should lead is actually not the way ahead. If all groups have to come together, that is the way ahead. And one has to be sensitive toward the fact that what is stopping these groups from accessing the benefits. And unless these groups, the groups who have been left behind, take into account the role of bureaucracy, the role of ruling political parties, as well as the opposition mainstream political parties, they will not benefit from this subquota kind of policies. And therefore, there is a need for a healthy dialogue between these scheduled caste groups who have benefited and who have less benefited. And it is only through dialogue they can come together and negotiate with various political parties, with the governments, and pressurize the bureaucracy to implement these policies that are meant for them. And it is only through that mechanisms that substantive social justice in true form can be achieved. I'll stop here. Thank you.
Okay, so thank you so much, Professor Mhaskar. So many points will probably have a cross discussion towards the end, but I think one of the very important point that has been missed probably in this judgment is that there has been an absolute absence of a national data, which is probably through a caste census or through a population survey and so on. So just there have been some kinds of jugglery of Indra Sahni judgment and Nagraj judgment and so on. They have gone ahead to sort of to manufacture a kind of a proposition to take a call that some have gone really so ahead, and so how ahead they are, that needs to be also questioned, because the recent World Inequality Lab report says that most of the billionaires' wealth has been held by the caste privileged sections. So probably there is no tribal billionaire or a Dalit billionaire in this country. So this also probably Professor Mhaskar has been writing and doing a lot of research on private sector reservation and trying to make that point. Even recently, yesterday or probably, there is a 3-part series of Hindustan Times data set that has been published, where they are saying how in fact the reservation, even though through political reservation there have been some MPs and MLAs from the SC/ST sections are coming, but are they getting the top ministries, the council of ministries, whether in the central government or the state governments? So this is again at the backdrop of what we are discussing. In fact, very interestingly, another important point that Professor Mhaskar has mentioned is that unsettling, and I found it very, very intriguing, unsettling the settled debate. And we have been kind of telling this time and again, that this is the settled area, and you have, which is what has happened with OBC reservation. Recklessly, there has been creamy layers, sometimes added, sometimes dropped. But for the SC/ST reservation, since it's constitutionally drafted, so they couldn't do, but they have entered through Article 15 and 16. So, but I don't know, well, like in the, I mean, whether there is at all any reservation that exists in this country right now which is very, very meagre at this point, because we are living in an NFS era of not found suitable. Even if there is a small, there is few posts in the IITs, IIM, central universities, state universities, and colleges, they find SC/STs as not found suitable and not really up to the quote unquote merit in the grammar of their upper caste definition of merit. So I think I wouldn't just take much time. We'll have this discussion towards the end. But without further ado, I invite Dr. Shailesh Kumar, a very dear brother, that to deliver his lecture.
Hi, can you hear me?
Yes.
Perfect. Thank you so much, Subhajit, for this opportunity and, of course, for organizing the series of talks. This is, I think, very much needed, looking at what has been happening in India. And thank you so much, Professor Mhaskar, for laying the foundation. I think you have covered specifically those points which I might not have covered. And I think you have given a very clear understanding, I would say, of what has happened in the so-called independent India's history when it comes to caste-based reservation. There's another, I think, myth that circulates and is being perpetuated by certain communities, which is that reservation is, just caste-based reservation. Whenever we talk about reservation, it's kind of, let's say, meant to be only caste-based reservation, whereas we know very clearly that reservation is of different kinds. We have gender-based reservation. We have, in some context, even let's say class-based reservation. Even before EWS came in, we had management quotas where people, of course, got in through money and at zero marks as well, if to give an example. And there have been all these different kinds of reservations which have been going on. But then we do find that how the narrative around reservation is built on caste-based reservation, and of course there is a lot of, I think, negative movement around it as well. And I think the root cause is also because we have lack of, I think, teaching, which I now can connect with the UK and the Western world on caste and casteism and caste system within Indian schools and colleges. And I think that is another point which I'll be making to later on in my talk as well, as to why that has to happen a lot more in India, as I see personally now, in my 7 years in the UK and the rest of the Western world, how, let's say, in schools and in colleges, you have teachings on race and racism and colonialism and all, but we still don't find it in Indian schools and colleges as much as we would have liked it to be. Now, there's certainly a conundrum, coming back to, of course, what we have to discuss. Now, this Davinder Singh decision has grave political and sociological implications on the ground, as both of you have put already. And as someone argued, I'd also bring this angle that the Supreme Court's verdict in an 18-year or 20-year-old appeal came serendipitously to the ruling party's rescue without the party actually needing to take any political risks. So it has come through the Supreme Court. But the problem, I would say, is bigger and more complex than that, and certainly merits a deeper analysis. It's also about formal versus substantive equality, as you earlier pointed out, which is, okay, if we give something to, let's say, three different kinds of people with three different capacities and requirements, if we provide them equal opportunity, that might not be sufficient for all three of them. And that is formal equality. So what we need to do is we need to give substantial equality, which means that we need to actually cater to these three different requirements of those three individuals by giving different, let's say, kinds of opportunities. And this is where I think the Supreme Court has come in and has used this very important and interesting term so much. And we certainly tease that anyway, in Article 14 and otherwise as well, whenever we have jurisprudence on equality jurisprudence talks about formal versus substantive equality as well. Even in intersectional approach, when we talk about intersectionality and all, we have discussions and debates on formal versus substantive equality. Now, how I would be going with my talk is I will be giving a bit of constitutional history or historical background, more around parliamentary sovereignty vis-a-vis um, the judicial review, because this has been a very big debate, especially since India got independence. And since, as Baba Sahib also said, we have political democracy, or we have got political independence, but certainly we do not have that kind of social democracy or social independence as we would have liked. And unless we have achieved that social liberty or social democracy, this kind of political democracy that we have created might fall. So I'll start with the constitutional historical background, and then I'll move to the main issue of subcategorization, talking about the Supreme Court's decision, the good parts in it, and then the problems and so-called solutions, and then the final words. So the political economy of substantive social justice is also, I think, the history of political economy of the Indian so-called post-colonial or independent state, which in turn is a history of the political struggle between parliamentary sovereignty, which is the amending power of the parliament on one hand, and judicial review, which is the court's power to review executive or parliament's decision on the other hand. Now, over all these decades, the courts have in some ways struggled on two fronts against institutional erosion: the larger constitutional front of judicial review versus parliamentary sovereignty, and the related but separate front of the independence of judges from executive manipulation and control. And this is, again, a very important topic that has to come in when we look at judicial independence or judicial review vis-a-vis parliamentary sovereignty in the bigger rule of law context. Now, certainly we do not have this, we do have an Anglo-Saxon legacy, but we do not have, let's say, the way Britishers have this British parliamentary sovereignty in the UK, which is the power of the parliament here in the UK, the Westminster Parliament, to make or unmake any law. And that is kind of an absolute parliamentary sovereignty, which we do not follow in India. Now, since, as I said earlier, 1947, we have had this debate around political democracy versus social democracy or social liberty. And there has been an aspiration to remove severe inequalities by creating a socialist state, starting from the Nehruvian era to going forward during Indira Gandhi, and then forward from that. And the biggest obstacles that have been there have been around land ownership, access to public higher education, and opportunity in public employment. And that's why we can see that how even the fundamental rights, especially around 14, 15, and 16, they kind of circle around these. And there have been a great debates, actually, historically, since independence on these issues. Now, to give you just kind of an anecdote, for Nehru and his like-minded colleagues, and this is, I'm quoting from Rudolph and Rudolph, who wrote a fantastic book a couple of decades ago titled In Pursuit of Lakshmi. So for Nehru and his like-minded colleagues, parliamentary sovereignty opened the way to legislate social transformation and a planned economy. The primacy of parliamentary will over a judiciary bent on protecting citizens' rights, particularly property rights, was a necessary condition for realizing a socialist society. Now, Nehru's strongest statement on parliamentary sovereignty came during the course of the Constituent Assembly's debate on compensation for the property that they thought of taking away from the feudal lords then, particularly the landed property. Now, Nehru said no Supreme Court and no judiciary can stand in judgment over the sovereign will of Parliament, representing the will of the entire community. Ultimately, the whole Constitution is a creature of Parliament. That was the statement from Nehru. Now, even so, he remained silent during the debate on the amending article a few weeks later, which was way back in September 1949. Now, Nehru was kind of in favor of amendment by simple majority, which is plain and simple. More than 50% of the parliament agrees to something, and then the parliament can amend any constitutional provision. But he did not offer a motion to that effect. Instead, Nehru actually acquiesced in a statement by Dr. Ambedkar, who was, of course, law minister and chairman of the Assembly's drafting committee, that the Constitution is a fundamental document and that utter chaos would follow if it could be amended by a simple majority. And that was set by Baba Saheb, and then, of course, in a way supported by Nehru. Now, this tussle between parliamentary sovereignty and judicial review went to its peak during the 1970s. And you have had then Indira Gandhi as the prime minister, and there have been statements that judiciary, particularly the Supreme Court, is acting as a roadblock to India's social change and socio-economic equality. And that is where also you have had then land reforms and redistribution and the arguments around the property rights of landowners. Uh, Now, during India's first 2 decades as an independent state, successive Congress governments bent on carrying out social and economic reforms, particularly the land reform, and they confronted successive Supreme Courts bent on upholding fundamental rights, but particularly property rights. And you can see the tussle, the tension there between the government, the executive, and the judiciary, particularly with regard to property. Now, further, uh, in the face of India's radical inequalities and powerful political support for some redistribution, the court might have exercised its judicial imagination by drawing distinctions between property rights and other fundamental rights. But what the court did instead, it relied on legal, as again Rudolph argues, solipsism and formal and technical interpretations of the constitution, which inhibited the efforts of Congress governments to effect social and economic change. Now, this inflexibility of the courts actually encouraged the state to circumvent and weaken them. And the conflicts intensified after, of course, Nehru's death in 1964 and Congress's near loss of the fourth general election in 1967. Now, they intensified further in 1970s when Congress under Indira Gandhi's leadership won impressive legislative majorities in the 1971 parliamentary and 1972 state elections. And they reached their height during her emergency regime when the government seriously considered abolishing a Supreme Court capable of judicial review. So you can imagine that the debates then was actually about abolishing a Supreme Court which was capable of judicial review. Now, as India entered the 1980s, the state issue of parliamentary sovereignty versus judicial review remained a principal line of political cleavage. Now, again, you have had big swing between 1967 and 1977. And then we have had several dimensions of constitutional interpretation which were at issue. You can think of amending power of the parliament. You can think of property rights, particularly the acquisition of property by the government. And you can think of citizens' liberties as well. Now, the pendulum actually swung its furthest points in 1967 and 76, when we had two very important constitutional judgments from the Supreme Court. And at one extreme, we have had the Golaknath judgment from 1967, which actually restricted Parliament's amending power. It barred the Indian Parliament from using its constituent authority to amend fundamental rights, protecting the liberties of citizens. At the another extreme, you have had Parliament barring the Supreme Court's power to review. And this came through the 42nd Amendment, which was passed during the emergency in 1976. And it laid down that there was no limitation whatever on the constituent power of Parliament to amend the Constitution. Now, it also added another provision that no law declared by Parliament to be giving effect to the directive principles of state policy could be called into question by the court as abridging fundamental rights. And most notable of the decisions was that in the Keswanand Bharti case, which is again a very prominent, famous case from 1973, which actually reversed Golaknath's bar to parliamentary amendments affecting fundamental rights, but it did protect judicial review by limiting Parliament's amending power to the matters that do not destroy the Constitution's basic structure or so-called essential features. And that is where we have got then the basic structure doctrine. But then after the Janata Party's 1977 electoral victory, this doctrinal controversy and institutional rivalry abated somewhat as a result of this so-called legislative stalemate. And then again, you have had the issue of parliamentary sovereignty vis-a-vis the authoritarian state versus the liberal state and the rule of law. So you have had then, of course, emergency, which was this authoritarian state of Mrs. Gandhi, whereas you have then had the JP movement and the bringing back of liberal state after that election. But certainly then the pendulum continues to swing between extremes on this issue of whether we should have parliamentary sovereignty or whether we should have constitutional sovereignty, which is where the judicial review also comes in. Now, things certainly then further changed in the 1980s and 90s. We have had Mandal Commission report, its implementation by VP Singh. You have had OBCs coming into state power, and also what I think Christoph Jefferle calls the silent revolution, right, which was taking place. We also then saw this Rath Yatra and Babri Masjid as an antidote to, a kind of a communal response to this Mandal movement. And then we also saw at the same time a very fundamental change in 90s, which was the collegium system. So we have had 3 judges' cases, starting from the SP Gupta case, the judges' transfer case. The second case was the second judge's case, and then the final case in 1998. And all these 3 judges' cases actually then culminated into what we have the collegium system, which is judges appointing themselves. And there wouldn't be any interference, so-called, by the executive and the legislature. And this is very important. Why I've been sharing these historical facts is also to tell us how the judiciary has acted and reacted to the changing, let's say, society and politics in India, and then particularly to the issue of reservation and representation within the judiciary as well. Now, I wouldn't go into the details of those cases, but one thing is very important, that in the third judge's case, which was in 1998, it wasn't a case actually, but an opinion delivered by the Supreme Court while responding to a legal question regarding the collegium system. And guess what? That was raised by the then President of India, K.R. Narayanan, who was the first Dalit to become an Indian president in July 1998 under his constitutional powers. And of course, we know, the rest is constitutional history. We have had then the JSC Bill 2013, NJSC Bill and Act 2014, and then its declaration as being unconstitutional by the Supreme Court by a 4:1 majority in 2015. So we have seen how things have kind of been taken by the Indian judiciary when it came to, let's say, questioning either their representation or, let's say, also the issue of parliamentary sovereignty vis-a-vis judicial review. Now, coming to the main issue, which is of compensatory discrimination, as Mark Galanter called it in his book, Competing Equalities, or affirmative action, as we call it, and who are its beneficiaries, as I think Professor Mhaskar also pointed out. So, even after compensatory preference is formally established, who is to benefit continues to be a central question, not only in designing, but also in administering programs, and crucially important for the continuing justification of these programs to others. A public and professional discourses about the identity of the beneficiaries is therefore an integral part of the operationalization of these programs. And therefore, it raises questions of both personal as well as group identities, right? And this is where we think of, okay, should we look at an individual from the SC background who has, let's say, become richer or has acquired certain status, and should we put him out or his family out or her family out? Or should we look at it as a group identity? Because whenever we think of caste-based reservations, we think of in the sense of SCs, STs, and OBCs. We do not look at, okay, rich SC, rich OBCs or rich STs. Though, of course, we have had, again, another judgment or let's say another judicial innovation around creamy layer in OBCs, and also denying of, let's say, certain kinds of reservation in promotion, again, on the ground of so-called merit and effective administration, which, again, I'll come to later in my talk. But before I move forward, I think we need to think of also the Supreme Court judgments, like several Supreme Court judgments on caste-based reservations. And we need to think of the judicial approach. Is this bona fide? Is it malified? So you can think of starting from OBC to OBC creamy layer, to economically weaker sections, to the SC/ST subclassification in creamy layer. We also had, I think recently in 2018, a 5-judge constitution bench of the Supreme Court holding that the state cannot extend reservations and promotions to individuals from the SCs, STs communities who belong to the creamy layer. So We can also then look at the judicial creation of this 49.5 reservation limit. So all these are judicial creations. These haven't actually come from the parliament or from so-called the will of the people or will of the communities, right? And that's why these raise two very important questions. One, does subcategorization lead to creamy layer and thereby weakening or elimination of the caste-based reservations for SCs and STs? And if this reservation is threatened, does this mean the constitution is under threat? And of course, during elections, we have had a lot of discussions, debates around this, and political parties, threw all the power in to kind of talk about these issues of constitution being under threat. Now, another point is also around efficiency and merit. And I think, again, a very interesting literature is from Michael Sandel, though, of course, in a more sort of Western perspective. But a few points I'll pick from there, which is, I think, the book is called Tyranny of Merit. And Sandel argues that these are dangerous times for democracy. And he says we live in an age of winners and losers, where the odds are stacked in favor of the already fortunate. And this is the same thing when we look at India, particularly with so-called dujas, or so-called the upper caste people, right? Looking at the kind of social and cultural capital or economic capital that they have gained historically in India. Now, Sandel further says that stalled social mobility and entrenched inequality give the lie to the promise that you can make it if you try. And this is what the argument has always been. Even if you look at the social media, the narrative is always that, oh, what is stopping you from competing with, let's say, under the general open category? Just you need to try. You are just being lazy. All these so-called lower caste people are lazy. They just don't want to compete. So this is what is being challenged and questioned here by Sandel. And then he says that, and the consequence is a brew of anger and frustration that has fueled populist protest. And he then goes on to argue that to overcome this polarized politics of our time, we must rethink the attitudes towards success and failure that have accompanied globalization and rising inequality, something which I think Subhajit was also pointing out. Look at who owns the wealth in India. I think the data clearly says that 90% of, or more than 90% of wealth is owned by upper caste people, right? Who owns the land, right, in India? Where does land ownership lay? So all these are the questions around, winners and losers and the globalization and rising inequality. And what it does, I think, is it highlights this sort of hubris of meritocracy generates among the winners and the harsh judgment it imposes on those who are left behind, right? And I think it's very then important. It becomes very important then to think of role of luck in human affairs, the accident of birth, because what is caste? It's an accident of birth, right? What is, let's say, ownership of wealth? It is accident of birth, especially in the Indian context when we don't even have, let's say, inheritance tax for, it's really ridiculous to think of, because in the UK and several other developed countries, we have inheritance tax. In India, you don't have inheritance tax. And this is another very important point when we think of, let's say, land redistribution or, something where we bring more parity or substantive equality to the Indian society. And this is where I think Sandel says that we need to give more attention to the role of luck in human affairs. And we need to be more conducive to an ethics of humility and more hospitable to a politics of the common good. And this is, again, something which brings us to the privatization and public debate, right? That, okay, the more privatization takes place, rather than benefiting those who are at the lower rung of the society, it creates more inequalities. And there are ample amount of evidence to showcase this. Now, I have also written a piece, I think, with my friend and colleague Arvind on, I think, life law, which was titled 5 Messages for Anti-Reservationists in India, which is based on the Supreme Court's Neat judgment, where I pointed out how our understanding of merit and efficiency is so flawed in nature, particularly in the Indian context. Now, let me move forward to the subcategorization and creamy layer issue. And I think Professor Mhaskar has already explained the difference, because I think it's very important. And I did see on social media some people mocking the protesters, or let's say those who were participating in the 21st August protest, the democratic protest around this issue, that, oh, they don't even know about creamy layer, they don't even know about subcategorization. But of course, we need to understand that different people have different capacities and different access to information and knowledge. Not everyone can be as articulative and as informational as others who have the understanding of what they are. Now, let's move to the Supreme Court's judgment. I think I don't need to go into the details again, but then we have had 6-1 majority. And 7-judge bench permitted subclassification. 4 judges also gave opinions on creamy layer, including the only judge from the Dalit community, Justice Gavai. Without this being a question before the bench, this wasn't even a question, and they didn't need to get into this at all, which means to exclude the wealthier and more advanced members within a group from the benefits of affirmative action, which thankfully do not have any legal force, but again, which might have implications on future directions. And the sole dissenting opinion came from Justice Bela Trivedi. But then one interesting thing is also to look at in the decision is there's hardly any reference to literature by Dalit or other Bahujan scholars on their experiences and what had changed, if anything, in India in terms of Dalits or, let's say, people from ST communities, their experiences. It's a long judgment, but still you will struggle to find these literature in that judgment. So I wonder if the Supreme Court judges and the kind of support they have from their assistants were not enough to help them track all these literature, which is now abundantly available. Now, again, you have Article 14, 15, 16, I think something which already have been touched on, Article 341, again, have been touched on as well. Now, I will directly come to a few paragraphs from Chief Justice of India, Chandrachud's opinion. I think in paragraph 134 of the judgment, he says that it is evident that there is no one form of untouchability, and untouchability, like other forms of social disability, differs in degree and severity. Now, further in paragraph 137, he then brings in Ambedkar, and he says that Dr. Ambedkar observed that the differences in the test of untouchability do not indicate differences in the conditions of the untouchables, because the notion underlying both the standards would be the same, that it is below the dignity to interact or touch persons of certain castes. He observed that the difference in the rigidity with which untouchability is practiced does not eliminate the notion of such a practice. Now, it is really intriguing to see how, on one hand, he is saying that there is something homogeneous working for entire Dalit category as a political identity, which is the issue of untouchability. But on the other hand, there is a section called empirical evidence, where he, among other things, cites a study on Gujarat to say that untouchability is practiced by certain Dalit caste against other Dalit caste. Now, again, this is a study, I don't know how much it is supported by the recent literature on a practice of untouchability, and if it is really, let's say, happening in today's time. Again, the judgment doesn't go much deeper into that. It just throws this one in and says that, oh, even among Dalits, there is untouchability being practiced by one Dalit caste against another Dalit caste. Then there is also a reference to, I think, Indra Sahni judgment, in which a 9-judge constitutional bench of the court allowed for subclassification within the broader category of backward class. Now, he held that the 1992 judgment had not limited the application of subclassification only to the OBCs. But if you read the Indra Sahni judgment, the court has categorically stated that it was not concerned with the question regarding members of SCs and STs. And moreover, I think we are yet to have a critical perspective on the Sahni judgment. Why was subclassification allowed in 1990s, right? When we had this so-called silent revolution taking place. Were there any political reasons? Why creamy layer was brought within OBCs? What was the logic behind that? What was the political and social context of that Indra Sahni judgment? Then also important is for us to look at the dissenting opinion, the sole dissenting opinion by Justice Trivedi, which is where I think it is said that a constitution bench decision should not have been disregarded by a smaller bench without substantial reasons. Why a three-judge bench or a five-judge bench referred this matter to a larger bench, right? What was the reason behind that? And then she says, different from the other six judges, she said that the presidential list specifying the scheduled caste under Article 341 attains a finality upon publication. So only the parliament could alter this list, and any subdivision or regrouping by the states is impermissible, which is something I think Anand Teltumbre has also argued in his recently written pieces. Now, the dissenting opinion also said that the states lack the legislative competence to subclassify the scheduled castes for the purposes of reservations, and any such action would actually undermine the uniformity and special status accorded to the scheduled caste by the presidential list, disrupting the intended structure and protections under the Constitution. And then she says the scheduled caste, despite being drawn from different castes, form a homogeneous class due to the presidential notification, and therefore they should not be subclassified or regrouped by states for affirmative action. Now, I'll also touch on the brief little positive things that the judgment as a whole, the majority opinion, has, right? So, one of the most important things that I found out was that in some way it settled the, again, ever reinforced doubt circulated by upper caste around efficiency as a limitation to reservations. That, oh, this is a very famous joke that goes around. Okay, if someone has come from a reserved category, if someone is practicing medical, is a doctor, would you go and get operated by that person? Now, again, these are the stories very badly framed and understood, which are reinforced in society on an everyday basis. So that's the one good thing that has been done by the majority here. I think another important thing is that the judgment, the majority opinion did, was also that it placed some constraints on states' power to subclassify. So it didn't say that, okay, the states can just go on and subclassify as they want. It said that the state must prove that the group or caste carved out from the larger group of scheduled caste is more disadvantaged and inadequately represented. And the subclassification must be on the basis of empirical data relating to backwardness or representation in public services, not on the whim of government or political expediency. And that it will also remain open to judicial review. Now, these are a few of the positive things that came out of the judgment. But the question is, will it happen in this manner? And what does our policy and practice or implementation experiences say? We can have a look at the EWS, the economically weaker section 10% judgment, the policy. Was there any empirical data to say that, okay, we should give 10% reservation to EWS? No data was available, and still the parliament went ahead and did it. And then on top of that, even the Supreme Court then did not hold this as unconstitutional. Another positive thing I think that came was that the state can't go as wide as public employment as a whole. This is another very important issue because counting public employment as a whole was a negative aspect of it. So now it says that the inadequacy or lack of representation requirement is to be established in the subgroup of services like grade A, B, C, and D, and so on. So we have seen, because of the historical linkage between caste and profession, most of the people from, let's say, the depressed class or the SC/STs communities, they tend to go into the C and D group services. And there is now, I think, empirical evidence, the data available as well, that in higher, let's say, grade services, let's say Group A and Group B, you do not have enough representation from SC and ST communities. And certainly, therefore, this has to be demonstrated within these grades of services of the state. Then I think another important point was that reservation is not antithetical to merit, including the promotions. Right? And this is, again, very important because this is another narrative that has been kind of reinforced and perpetuated that, okay, reservation is always opposite to merit, and we need to look at the merit. right? And this was another reason why in promotions, I think reservation was not allowed in certain contexts as well, because it was said that, oh, once you have taken it, you have kind of achieved something, and also we can't allow reservations in promotions because it hampers the efficiency or it's not meritorious enough. But then there are several problems as well. And I'll now quickly run through the problems and then we'll try to finish my talk. So first, of course, the methodological approach and the creamy layer issue. Both are very problematic and raise questions on judicial intention and judicial motive. Justice Mitchell's judgment is worst, as even more unusually, it is almost entirely dedicated to examining the desirability of reservation as a tool of empowering backward communities. Now, this was, again, as I said earlier, never the subject of the litigation. He argues typically as a typical Dvija or upper caste person for economic status and geographical location, etc., as factors to give reservation, and to give reservation only to first generation or one generation. So again, these are same things perpetuated generally. And overall, a majority of judges finding in favor of creamy layer exclusion is a big barrier for the project of substantive equality in India. If the Supreme Court judgment is actually even trying to talk about substantive equality in India, they should have literally not even touched or have imagined to speak on the issue of creamy layer within SCs and STs. And there's literally no judicial accountability to say these things in a judgment. And that's another problem that we have in India with the higher Indian high judiciary. Now, discrimination as a group and not as an individual, of course, as I have said already, untouchability is not a class issue. And the scheduled castes were formed on the sole criterion of untouchability. So groups within SCs cannot be treated differently, as it would be unconstitutional and might violate the right to equality. And there's another argument that has been given against this subclassification by the state. There are several other arguments in terms of the socio-political implications that this judgment can have, which is the likely, let's say, weakening of socio-political strength of the SC community as a group, as a single political identity, right? The Dalit identity, and their ability to act as a pressure group and lobbying with the state. And we have seen how this has, let's say, impacted how different governments have treated the SC community or the Dalit community as a whole, right? There's another argument that it could also deepen social divisions, weaken the Dalit movement, and we can already see some sort of fractures that are coming in, and alter the landscape of caste-based politics in India. And it could actually be seen as a step towards eventually diluting or even dismantling caste-based reservations. Further, I think, as Professor Mhaskar said, social mobility does not lead to elimination of caste prejudices against the Dalit identity. We have seen several examples, including big shot politicians and bureaucrats, that even them being at that highest political position and at those kind of bureaucratic positions, they have faced discrimination or untouchability just based on their identity as a Dalit, as a person from scheduled caste community. And subclassification can rather lead to political realignment and mobilization, and has very big potential to break this one single political identity. The biggest challenge, I think, is the roster system and the NFS, I think, which was pointed earlier by Subhajit as well, that we have seen. And I can give you one example from my own experience in JNU. I remember there were several, and I'm sure there are several such examples in other institutes of so-called premier institutes in India, that you have candidates from reserved categories getting highest and second highest marks in the written exam, but then they get 0 or 1 mark out of 30 marks in interview. And this is again a very serious concern, which the Supreme Court or no one else, even the governments, have taken into consideration. I can think of, let's say, in the West, you have provisions of keeping a person from racialized minority community in the interview rounds. Now, I'm wondering if India has that kind of provision to kind of tackle this caste biasness or discrimination that goes on during interview rounds. Because not only a lack of material advancement of these communities, but also caste bias, kind of creates these problems. Now, in terms of solutions, I think Professor Mhaskar has already kind of given the way forward. I have a couple of points to make as well. I think certainly we all want substantial equality, but there needs to be material advancement of SCs and STs for that. And that can only be done by land reforms, access to education, particularly for the landless. And you can look at, let's say, Punjab, earliest example on the basis of which this big case came in anyway. It has 35% Dalit population, but still they have hardly 2 to 3% of land holding, if I'm not wrong. So you can imagine that despite this law, which is subcategorization amongst scheduled castes, being there since 1975 till 2004, which is 3 decades, 30 years, where is the advancement of those subcastes or of those castes who were given benefits through that subclassification in Punjab? Now, those who are far behind among the SCs and STs certainly need more support, but in terms of material advancement. And the objective of reservations should be to integrate them into the mainstream by securing their representation in education and public employment in proportion to their population, not to remove economic backwardness. And I think many Bahujan education reformers also argue for having a single schooling system, right? So gradually eliminating all private schools. Now I can think of UK, let's say. Here you have 94% students who go to state-funded schools. Now, you can also think of universal healthcare in India, like we have here in the UK. But then, do we think that democratic India can ever have these? Right? This is again a very big question. Caste census, I think, which was pointed out, have empirical evidence on numbers of SCs and their representation. So, have that on the floor. That okay, what kind of representation SCs and STs committees have across different sectors, not only in judiciary or in academia, but there are several other sectors. You can think of media, you can think of sports and culture. There are all these sectors, cabinet, everything. And I think the responsibility is also on us to kind of work and produce empirical evidence of experiences and challenges and improvements over the period of time. I think finally, I would say that there has to be some sort of a broader, calmer consensus among Dalits and Bahujans in terms of increasing the share of overall SC/ST quotas centrally and state-wise. So the fight should be towards expanding the present quotas by breaking the existing judicially created ceilings. And as Professor Mhaskar clearly said, that anyway, we hardly have 2 to 3% public jobs. And access to state power in the kind of severely unequal and feudal society we have in India is very important. And that's why we can see so much of hue and cry even for those 2% public jobs, despite 98% of Indian jobs being entirely in the private sector, and which is certainly dominated by the so-called upper caste people. Now, in terms of final words, and I'll wrap up my talk now, I think weakening of the caste-based reservation has certainly always been a Brahminical or a ploy, if it is a ploy at all. And we need to remember that there will be a growing fear among, let's say, so-called upper caste about the rise of the plebeians, to say, as they're losing control over their birth-based control and power over resources. And I wouldn't say that it is solely an RSS BJP agenda, as some scholars have pointed out, because if you look at it historically, that's not the case. And there are genuine grievances. Though, again, as I said, different people have argued this based on their political affiliations. But in caste matters, we need to note that this right-wing, left-wing binary does not work. And we have had all Congress, BJP, and even the left parties attempting to deny or weaken caste-based reservations. And there is a deployment of Brahminical mechanisms with OBCs and SCs as faces, right? And I don't need to go deep into that to kind of flag that out. Now, having said that, Dalits, however, present a more complex challenge due to their allegiance to the historical anti-Hinduism or Hindutva stand of Dr. Ambedkar. And I think there needs to be a caution among SCs and STs on the saffronized version of Ambedkar, circulated by the RSS as well. And I think there has to be Ambedkarite Bahujan leadership created that is inclusive in terms of subcaste even within the SC/ST committee, with a Bahujan ideology and not any theocratic or ethno-nationalist ideology. because we are already seeing what's happening in our neighborhood as well, both on the east and west, right? Um, then I would say we can also look at Supreme Court's watering down the prevention of atrocities provisions, arguing that it is misused without any empirical evidence. But then it doesn't employ the same approach or logic for other criminal statutes, like, let's say, anti-terror laws, which is so much misused by the state, like UAP and all, right? Even the Maharashtra government, I think, came with a similar law recently. But then Supreme Court will not take that into accountability or that into consideration. It will also keep mum on the so-called bulldozer justice that is going on for a few years now. So again, the question on the judicial intention or motive comes in here. Supreme Court also doesn't care for substantive justice or substantive equality when it comes to EWS, let's say, for example, among the unreserved categories, right? Because I remember there's a good saying by Chandchu in this judgment. It says, getting the first bite at the apple, right? But then why we don't think of getting the first bite at the apple among the unreserved constituency or communities as well, right? In a country, and this is which I have been saying at different fora as well, that in a country like India, where the average GDP per capita income annually is only, let's say, 1.5 to 2 lakhs rupees, how can we even imagine something like an economically weaker section category created, which is targeting or giving the limit of 8 lakhs rupees per annum plus 5 acres land, which is not even for OBC creamy layer people. So again, and on top of that, this was never kind of declared unconstitutional. So it's a really baffling to me, and I'm sure to many others, that how EWS, which is actually targeting the economically weaker section, never came into Supreme Court's mind that, okay, are we giving substantial equality there? I think, of course, the issue of then making the Supreme Court or the higher judiciary generally representative also comes in without losing its independence. And as I've said in the past, legal education and legal profession need to be made more diverse as well by devising EDI mechanism if we want the higher judiciary to become more diverse. I think lastly, I also again will bring in, Professor Tel Tumre's point that reservation is really complex, multi-edged tool that requires extreme caution in its application and was never the only means to achieve social justice. And meaningful social and substantive equitable justice can only exist in an environment of broader justice, which could be created by universalizing key elements of empowerment. We can think of healthcare, education, land reforms, and also with an intersectional approach. Something like a poor, let's say, upper caste or Dalit woman who is likely to be worse off than a rich upper caste or Dalit man belonging to the same caste. But again, alas, these are the areas that successive governments have certainly neglected over all these decades. We also then need to look at the reservation jurisprudence and its doctrinal incoherence in India. And I think that hasn't still been studied from a subaltern perspective. And that again raises questions about Indian academicians and their social locations, perhaps. Now, I can tell you from my experience in the West, in the UK especially, you have several centers for race and law or around race across most of the UK universities that are led actually by the racialized minority communities, brown, black people. But you can think of how many such centers exist in India, in Indian universities. So again, the question comes on what have been Indian academicians doing, and is their social locations playing a role in it? I think we also need to have more and more data on caste diversity and representation as a starting point across judiciary, media, academia, sports, Bollywood culture. And I think we have been conditioned to ignore these. So I think at this point, I will wrap up my talk. Thanks so much for your patient listening. And of course, I'll be happy to hear your comments and take questions. Thank you.
Okay, so thank you so much.
Sorry if it was very long. Apologize.
No, yeah. So, so many issues have been flagged and very, very intriguing. And probably if I can pick up the last line and we can kind of discuss a bit, is that probably Justice Mittal's arguments he wrote a separate judgment, even though it's a concurrent judgment, where he talks about casteless society, caste system, Vaishyavi, the Varna system. And there he goes on to say that we have meticulously implemented reservation. And there he says that, in fact, the Varnas, Ramcharit Manas, Gita, and so on, the kind of Varna system that is being upheld, it's on quality. It's a very qualitative. And then he goes on to say it's very contradictory that Gita thus only promotes Varna system, which is different from present day caste system. I mean, this is very baffling that the Varna system actually has set the discourse of how to create a hierarchical gradedness in various walks of life. He basically even has done a small structure of Brahman, Kshatriya, Vaishya, and Sudras, where he basically goes on to say that who are the Brahmins? There he says teachers, priests, intellectuals. I mean, look at it, that he himself is categorizing. And then he says that the Bhagavad Gita takes pride that Bhagavad Gita is the graded hierarchy, which is very inhuman, but he says that it is the intrinsic qualities of the Bhagavad Gita, that each of the Varnas have some intrinsic qualities, so that this is not really some kind of caste mechanism, but this is a quality based something. So this is
Subhajit, if I may just come in, it's not a first time. I think it's not the first time when a Supreme Court judge has invoked religious scriptures. We have had several examples, and I think some people have flagged this out, that what kind of judicial training is being imparted to these, especially
yes,
higher judiciary in India, that they are very often now and then invoking religious scriptures to make their arguments in a constitutional rule of law democracy. We do not have a theocracy where you keep bringing in all these religious scriptures and your notions around Hinduism and Hindutva, right? And still, to my surprise, I don't see, because I do know that judicial training to the higher judiciary is only given at National Judicial Academy, which is, I think, in Madhya Pradesh. But again, these are questions that need to be tackled, that okay, what kind of training are we giving to these judges? And if we say that these are the judges which we have based on merit, is this the merit we are talking about? That the judges do not even have an iota of understanding or access to empirical evidence, and without even mentioning literature and empirical evidence in their opinions, they are just kind of, it's like, someone has rightly pointed out that it's like sitting during an evening drink at some place, and then just kind of speaking out your caste biasnesses in your judicial opinion. And I think this is very concerning, and it's surprising that even the Chief Justice of India did not think it is important for him actually to speak about that particular opinion in public forums. So yeah, there we go.
yeah.
Thank you.
Sumeet sir, yes, yeah.
No, I think the only thing one can add is to such kind of things is that it's not about training these judges. What they need to be trained is that once they become public servants, and judge is a public servant as well. So once they become public servant and they sit on a public official, they can have their personal preferences. They can really like the text of Gita and everything, but that is a personal preference. But when they are in a public position, they should keep a distance from everything. And as a secularism, we have that definition that we have equidistance from all of it. So I think that needs to be practiced not just by judges, but all those who hold public positions, prime ministers, chief ministers, mayors, councillors. And in that regard, the Supreme Court judges pretty much have the highest level of impunity, that they pretty much can just say anything, and they know that they are not accountable. And I think that is something that needs to be questioned. It's about the accountability, and they seem to be pretty much unaccountable to anything. And that is the reason they can actually say whatever they want, and which is a very disturbing trend for a democracy.
In fact, I was reading Professor Gopal Guru's book, The Cracked Mirror, where he invokes experience of Dalits. And a very interesting argument he puts forward, where he says that both Gandhi and Ambedkar share one thing in common. For both of them, experience provides the vantage point for making epistemological moves. Where then Baba Sahib goes on to say that Gandhiji, I have no homeland. And so this experience of Baba Sahib is very different from, so is the experience of upwardly mobile Dalit and probably backward Dalit. It's the same. So you can't really just come in and say that. So the vantage point is very, very different. So they are on the basis of that. So Professor Guru says that, in fact, he says that, however, there is a fundamental differences between the two. Gandhi experiments with the experience of the self and others. Thus, the experience of Ambedkar and his community becomes an object of Gandhi's experiment. And which is very, very interesting that probably the experiences of Dalits is a matter of experiment for somebody who is not a Dalit, who has never gone through probably that. So he says, Professor Guru says, Ambedkar and his entire untouchable community do not have to experiment in order to produce experience. So, so a very, very intriguing point. He says, Professor Guru, in fact, untouchables are born into experience. So do not experiment with that. So this is basically an instance of the lived experience that Professor Guru actually invoked. But I think is also I just want both of you to comment on this, that how that there is because Professor Shailesh said that very arguably that there is, whether it's a bona fide or a mala fide kind of intention. So, but over the years, he has already, you have taken through the entire process of the evolution. But Parliament, should Parliament not be a more instrumental in terms of being the highest lawmaking body, and because how their power is probably kind of encroached here, and right from Champakai Durairism to till this date, Parliament has been kind of very silent. Probably so many big political leaders are not from the Dalit communities, the empowered political leaders, and that's why they are not bothered about it in terms of anything, the rulings and judgments that is coming out of SC/ST OBC reservation. So how do you look at it? How do you assess this, and where do you go from here?
Professor Mhaskar, you can go ahead.
Yeah, I mean, I think, see, one of the things political leaders also know through the experience that as far as judicial space is concerned, this is where they are absolutely weak. Because the only way they can actually get anything done is through the political space, which is parliament. And thankfully, in democracy, parliament is supreme over judiciary. And if you look at the experience of any kind of movements, that any intervention from the state or the parliament or assembly has come through the pressure of social and political movements. And as far as judiciary is concerned, there has been least expectation that on the questions of caste-based social justice, social justice can mean many things, but as far as the question of caste-based social justice is concerned, the Supreme Court or even the High Courts have absolutely been militantly against the rights that are being evoked. So I'm not surprised if political leaders have done very little in terms of reacting to the judgment, except for one or two reactions with Bharat Bandh and all. Because they know at the end of the day, that is not the space where they can actually win. It's not about the best argument will win in the court. If that is the case, I mean, we would not have an EWS judgment in the first place. Because what is EWS? It says economically weaker section, which simply means that because you are poor, you cannot access institutions. So, what the poor needs is money and not a reservation quota. So, technically speaking, the government should have said, okay, all those poor people who do not have money, the government will support them through scholarships. So to have a EWS quota and then to have the second problem, I think one of you said that it's also strange that Supreme Court is really misbehaving, to say the least. That to EWS it says 8 lakh is the limit. To SST or OBC it says 2.5 lakh is the limit. So in order for you to qualify as a poor or creamy layer, even if you earn more than 2.5, you are a creamy layer. But even if you earn 8 lakhs, you're still not. And that is the reason one of the advertisement I saw was that for associate professor, which means your minimum qualification has to be assistant professor. So even an assistant professor salary qualifies you to be part of the EWS. And therefore, you cannot necessarily have a quota for professor of EWS category. You can have, if in any technical manner, for
Yes.
EWS, for entry level. How can you have EWS quota for associate professor? Because you are already qualifying that. So
Yeah, because I
therefore,
think,
sorry, I'll just finish and
yeah,
then please correct me. Yeah, there. So this is something I have noted, that this is one of the most problematic things that the Supreme Court is deliberately overlooking. So it's not naive, it's not making a mistake. There is something consciously they are doing it. And it is not at all taking into account the wider problems of the society. That when you say income limit, it has to be income limit for all the schemes. Why do you have these variations? And this is a very problematic situation where I feel that only through parliamentary kind of procedures justice can be attained and not through judicial means. Yeah, Shailesh.
yeah, I definitely agree to what you're saying, Professor Mhaskar. I was just pointing out, I think another very big problem that has been is, I think, lack of writing or scholarship or critical
Hmm.
scholarship on judiciary itself.
Yeah.
And as I said in my talk as well, that might be that academicians' social location played a big role in that, because they were themselves beneficiary. So, if talk less about diversity, talk less about representation in all these power institutions, and continue holding power through those institutions, and that's why we have hardly any. Literally, I can count on my fingers as to what kind of literature we have had on both lower and higher judiciary, and
Hmm.
on the legal system as a whole. And it's really kind of surprising that we don't have much. And this is the reason why I think judiciary, particularly higher judiciary, hasn't faced enough, let's say, accountability challenges historically since
True.
India's independence in the last 7 or 8 decades. Um, and I think now, because things are changing, things are growing, and I would also say that because we have more OBCs and SCs and STs coming into academia, that we are able to at least see some sort of research and scholarship, and these kind of articles coming up around these issues, where people are actually openly saying that, okay, or let's say critiquing the judgments or judicial opinions from so-called caste or let's say a subaltern perspective. But otherwise, we hardly find this kind of literature. Whereas if you look at and again, I'm bringing in my own sort of here UK or Western perspective, which is every single smallest issue is a race issue here. Every single smallest issue is a colonial issue here. So, you don't find a similar approach in India or in Indian academia or even in the, let's say, Indian diaspora, which is now in the West. We have so many South Asian Studies Center, primarily dominated by Indians and Indian academicians here. And I personally know what South Asian Studies Center means and who are leading it. But then the issue is around, why have we not seen enough literature on higher judiciary, on representation within all these different institutions, and on the very reservation jurisprudence, right? So, okay, let's take all these, let's say, big, famous 8 to 10 judgments of the Supreme Court, and then do we see a pattern there? Can we then identify or infer some kind of judicial intention or judicial motive from those judgments? Do we or can we say that, okay, it clearly depicts that because of the collective institutional caste background of the higher judiciary, we have had problems as to how they have approached the caste-based reservation issues. So I think this also needs to be tackled academically, and I think I'm happy that now I think things are changing, and people have started speaking against it. I can also sense that the public trust that judiciary held is also kind of waning, because I can see the judiciary also is changing its stance. You can see, and I was just kind of looking at how now they publish the promotion, notification, or the appointment notification. So if you look at the recent notifications that have been coming up from the Supreme Court, you will see that they now specifically mention the caste background of the judges. Whereas in the past, they have been very against it. They have always said, oh, one, we don't maintain the caste background data of the judges because we don't have that in the judiciary. And why should we put it out there? Because we don't, kind of follow that, or we don't have it. But now, because of this public protest, because of these social movements, because of this, I think a collective Bahujan, let's say, backlash against this lack of diversity in higher judiciary, I think the Supreme Court is being forced to reveal these things, to kind of disclose that, okay, how are you hiring people? Even I think the recent notification on the senior advocate designation, again, there was problem with that as well, both political and social representation wise. And public has actually pointed that out, that, okay, look, what are the criteria that, how have you kind of designated these advocates as senior advocates? What is the representation there? Is there enough social representation? Have you kind of intentionally left out someone? So I think things are changing, and that's a positive thing for us. But then again, there needs to be a lot more, I think, spreading of public awareness around these issues, and also awareness around the issue that, okay, there's this saying that, oh, not everything is caste issue. Everything is caste issue in a society where the very organization of social order is based on caste. So you can't just say that, oh, why you're looking into every issue from the caste angle. Of course you have to, because the very organization of Indian society is based on caste, and you can't ignore that question, and you can't ignore that fact. So I think things are changing, but certainly there needs to be more pressure from public and through social movements, and then through the parliament, which is, I think, the will of the people in true sense. And let's see how these things go forward.
Yeah. Yes. So we are kind of towards the last leg, but of the discussion. But I also found it very problematic with the subclassification of the untouchable caste themselves. Thereby, also as a political science professor, I feel that this is also like putting onus of the caste-based system on the Dalits themselves. Those have actually are the victims of caste and not the creators of the caste. So that means you are the perpetrators in a way, being subtly being that narrative is pushed. That the SC, ST, OBC. So that is why this creamy layer. Every other day there is a judgment on creamy layer. They are experimenting with creamy layers. That somebody has really gone ahead. But on the other, EWS passes through very, very smoothly, whether it's in Parliament or it's in the even the review petition before Chief Justice went on the EWS, and he dismissed it. Justice Chandrachud dismissed a review petition on EWS. So this speaks volumes of why we need to also reconfigure the kind of representation the judiciary has in terms of appointment of judges through collegiums. So this also I would like to very briefly comment, like you to comment on this, that how is it to put onus of caste on a casteless community, which is the SCs and STs. Is it? I find it a Jatpat Todok experiment or a Jatpat Todok moment here through that subclassification judgment. So that annihilation of caste should have been rather engaged with in this whole subclassification judgment, rather than in bits and pieces mentioning Dr. Ambedkar, which basically suits them. But Jatpat Todok is that history is very important always, and it will always remain that these Jatpat Todok guys, Mandal, those who wanted Dr. Ambedkar to deliver a presidential lecture at Lahore, in Lahore, these are actually the upper caste boys. And they wanted, when they read the earlier draft of Baba Sahib, they found it very difficult to digest. So Baba Sahib, because has put the entire onus, which is very correctly so, that the caste system is not my creation, it is the riddles in within your religious scriptures and within you. So you have to just sort of annihilate it, and he was giving suggestions to them. So I think, but this judgment is actually reversing that annihilation of caste mechanism that Baba Sahib had put forward before all of us. Yeah.
Yeah, I
Sir,
think,
Sumit sir.
yeah, no, that's very important. What actually I want to highlight here is that first point, I mean, I want to definitely make it clear that, of course, the data also shows that some SCs have not been able to benefit from the facilities. Okay. And there is no doubt about it. But what this judgment is doing is that there has been this constant drawing room conversations, and they have given a legal form to it, which is that whenever an Dalit or untouchable would raise the question that people are discriminating against them, they say yes, but also there is discrimination within Dalits. And this has been the trope for the last 60, 70, or even before. That the moment you say that somebody else is discriminating, they would say that no, but even within you there is discrimination. And that needs to be really discussed a little bit further, that it is not that simple. First, there is something called untouchability, which all untouchables experience. Now, within untouchable groups, it is possible that some groups may not like each other, which is very normal across the world. But the point here is that does that not liking stop the other untouchable groups from accessing public institutions? Are these SC who are beneficiaries, are they so strong that they can actually stop other scheduled castes from going to the school, going to colleges, or do they discriminate them just because they have a different kind of watch, because they wear different kind of goggles? The answer to such questions is no. And to say that there is untouchability within untouchability itself does disservice to the concept of untouchability. That yes, there can be differences of opinion about each other, because there are different untouchable castes. They will say they are higher than others, and they will all that's how Indian society is, that each caste claims more superiority. That is not the problem. The problem here is that can one group stop other group from accessing different kinds of facilities in public domain? And for untouchables, there are definitely hurdles across various groups. And there is absolutely no evidence to suggest that all those who Dalits or scheduled caste who have benefited from reservation policies or slightly better have actually done discrimination exactly in the form of untouchability to stop other groups. And so this is absolutely ahistorical, and it lacks any kind of empirical evidence. There is zero empirical evidence to suggest that people may hate each other, and that can happen with any groups for that matter. People may not like each other, but do they stop you? The answer is no, because we don't have any empirical, and even Supreme Court for that matter, and I think Dr. Shailesh has also highlighted that Supreme Court has not used some Gujarat evidence, but it's not a systematic study. In fact, there is no systematic study. Even the study from Tamil Nadu that the Supreme Court has very conveniently used is not based on a very systematic analysis which says that this particular group is in such a powerful position that they can stop the Arundhatiyas from actually entering schools, or there are public spaces, or going to the colleges, or they actually harass them. This is not the kind of evidence. Yeah, they may not like each other, they may not want to mingle, which is the nature of caste system, which is what the caste endogamous nature does. But the point that actually marks the untouchable from the rest of the society is that the rest of the society can actually prohibit them from accessing public space. That there is a repulsive effect the moment there is an untouchable in front. And that needs to be taken into account. And of course, the unfortunate burden lies again on the discriminated groups to produce mass evidence to show that actually it does not. And this is the way social science academia has always performed. I have just finished writing an essay on caste and modern industry in Bombay, which tracks a period from 1870 to 2006. And it should be out soon, where I'm actually looking at these people who said that caste will go away the moment large scale industries come. Caste will go away in the urban process, that the moment you go. But none of the scholars decided to, okay, let's take one industry, do a survey, and test the evidence whether caste matters or not. None of them. And yet, generation after generation, sociologists, anthropologists, political scientists have said caste is going to go away in urban city. So this non-using of empirical data to actually make an argument actually shows such a hollow system of even scholarly world has been. This is not a problem if they show through and good empirical data that yes, this actually doesn't really matter. You can be from any caste, but all occupations are open to you because I am focusing only on the occupation. And without getting into the rigorous exercise, scholars generation after generation have just stated the claim just because they feel that it doesn't. And this is a problem I'm sure law discipline will have and all disciplines. And that persists. And I think as scholars, our responsibility is to actually continuously produce the empirical information and actually look at the complexities. I'm not saying that it is the reality is black and white. But actually, even the complex system clearly shows that systematically exclusion is produced in different manner and privileges are also reproduced in different manner. And that is something that needs to be studied. So I think we need to really just, and this is the last note, and I'm sure we need to wrap up, is that this discrimination within discrimination thing should not be taken so lightly. It's an important issue, and we need to work on these things further. And using untouchable for any other group for that matter cannot be used so loosely because being an untouchable has a specific experience and specific history to it. It may have similar outcomes, but that cannot be compared to untouchability. So some people may be excluded from schools or public spaces. That is different and from untouchability. The outcome is can be similar. So in the case of racism, outcomes are similar. That there is segregated housing, schooling problem, higher education. The outcomes are similar. Just because outcomes are similar, we cannot say race is equal to caste. And for same reason, we cannot say, oh, these are new untouchables. So these are actually very problematic kind of assertions, which are ahistorical and lacks actually kind of in-depth inquiry. And as scholars, we must be careful about using these categories.
Yeah.
Yeah, I think similar is the problem with the law. I think law discipline as a whole in the Indian context, especially, first has been very positivist, which is very, let's say, it didn't have actually, let's say, this kind of sociological or critical understanding or scholarship or practice. So it was always like, okay, law means we read judicial decisions and then we critique those judicial decisions, and even those mostly without any political or social or historical context. And it's a very recent phenomena that you have these kind of social legal scholarships or critical legal scholarships coming in the Indian context. Now, especially in the criminal law and public law domains, I think another very problematic thing has been lack of engagement with caste. So you will hardly find, you have immense amount of literature on, let's say, criminal law, criminal justice process, criminal legal system, but then you will hardly find any interaction of those issues with caste being written in literature. So you will never see, here I remember I taught a module called Race, Crime, and Justice. Um, and the first thing that came to my mind was I've never read or heard anything similar in the Indian context when I look at, let's say, because if there is a social factor like caste, which is kind of an organizational factor of a society like India, how can you even say or think that, okay, then the way a law, a criminal law is enacted, the way a criminal law is implemented, the implementers of that criminal law, be it starting from police to prosecutors, judges, defense lawyers, magistrates, who all of them actually have some sort of social caste background, how can you even think that there won't be any impact of that social or caste background on the way they are implementing the law, or on the way they are interacting with certain kinds of victims? Because again, we do know for sure that most of the victims in the criminal justice system belong to the marginalized communities, belong to lower caste, belong to Muslims, right? Muslim communities. So how do we now think that, okay, those prejudices that exist in, let's say, private life will not come into public life? It's as I think, as Professor Mhaskar was saying, that judges need to be trained that, okay, you might follow something, but then don't bring it to that. It's a very difficult kind of thing, that if you are biased in your private life, certainly by coming into public life, you can't do away with that biasness, and that is why we also need to study then, how all these laws are working. Because I've always found this another problem, that in Indian academia, there's very descriptive approach. People just, it's like, okay, this is what the law is. But then why that is the law, or, if that law is being implemented properly, or is the law being implemented differently for different people based on their social and political and economic backgrounds? These are the studies that I think haven't been done enough in the Indian academia, particularly Indian legal academia. And I think that needs to change. And I have, from my side, also trying to kind of fill this huge gap that exists by doing social legal scholarship, or by also looking at how different criminal laws might work differently based on different, sort of from intersectional approaches in different geographical locations, based on different cultural background of the location and of the person, be it the victim, be it the defendant. And I think this needs to be taken up more seriously, as Professor Mhaskar said, in more in-depth manner. And there has to be, again, this kind of training given across the law schools, I think, particularly because law schools in India generally, I have been 6 years in law school in India, and I can say that I was never taught, let's say, anything around caste or gender except for the words when they were used in a particular law. So only in, okay, Article 17 says this, or 14 says this. Otherwise, other than that, I was never taught these things. Though, of course, I think things are changing. And I do know that there are a few private as well as public universities now where things are changing. People are teaching these issues and subjects. But I think we need a really big overhaul of how law is taught and practiced in India.
Yeah. So, thank you so much. I think, yes, the sociological analysis probably of the law is something in a very, very big way missing. In fact, to conclude this discussion, I would conclude by saying that this whole idea that Chandrachud has brought in the form of substantive equality is also very, very reductive. And it is also a kind of judicial fiction. That how do you call promote an idea called substantive equality in a country where the higher posts, especially in whether in academia, whether in judiciary, are all being sort of get kept by some particular castes. In fact, the wealth ownership, the land ownership, all of them. Most of the landless farmers are the Dalits. There is no Dalit prime minister yet. Even the secretary level, the most influencing bureaucrats, the most powerful bureaucrat positions, cabinet secretary, finance secretary of India, home secretary of India, including the ministers, education secretary, there have rarely been any representation there, and then there is absolute no reservation. These are all general posts. So I think I will conclude by making a very recent observation. Somebody has put in a chart of how some of these SC, ST, OBC students in IITs have been scoring very low, and that is why they haven't got the chances in the job market. We know that how job market performs through the application, anonymous applications sent by Professor Thorat in his studies. And also we know that how do, because Professor Mhaskar knows the job market discrimination and so on, he has done so much of studies there. Also the academia, how the academia performs, because we know how markings are being done. I can share a small experience that in my whole 7 years of teaching career, I have been on many occasions being told to give somebody, some particular cause as the better marks, and by some professors that that student does studies a lot, a brilliant student, meritorious students, but nobody recommended a Dalit or a OBC or a ST student for that student, that student is also brilliant. So that kind of perpetuation of caste system that happens in academia, all the post vice chancellors to registers to pro vice chancellors, deans are all again get kept. But I think let us let us continue this discussion academically, and I am very thankful to again Professor Sumeet Mhaskar, a very dear brother, big brother, and again Dr. Shailesh Kumar, again my very dear brother. So for joining me and not ever saying no, and staying with all of us for long, and providing us great insights. And I hope that this whole panel discussion would generate huge discussions around caste of judiciary and this subclass, how the subclass classification and this idea of so-called substantive equality would be panning out in the absence of any equality in a caste-based, Varna-based society. And thank you once again to you both.
Thank you, Subhajit. Yeah.
Thank you so much, Subhajit. And thanks, Professor Mhaskar.
Thank you
so much.
Thank you.
Have a lovely
Tapos,
weekend, both of you.
Yeah, thank you. Thank you. Yes. Tapos, we are ending? Okay. Oh, okay. Thank you.